We have to engage this eminent court to hear spurious allegations. And the comedy we thought about is called Much Ado About Nothing. And we'll be hoping to persuade you that the case before you is not only full of sound and fury but signifying nothing, but is much ado about nothing. Lastly, we came closer home and thought of a work of fiction in the realm of comedy and tragedy by a son of East Africa called Shaban Roberts. That work is called Kusadikika. And many of you, my lords and ladies who have read it, you will find it is a work in which people are invited to believe every allegation, however spurious, however preposterous. And we suggest to you that maybe the petitioner himself is taking you to be that country called Kusadikika by Shaban Roberts, in which if you're told the sun rises in the north, you don't apply your mind. Your challenge, my lady and my lords, is who do you believe amongst all these people with stories and counter stories? Is it the man whose name combines the names of two saints, John and Mark, and that name, Githongo, who was head of ethics in this country, but has had the audacity to produce before you forged logs? And when he is called out, instead of profusely apologizing, he says you yet another affidavit full of ifs and buts. Is it Arnold Ochieng Oginga, advocate of the High Court of Kenya? A learned man, to be fair, but who produced to you documents that were disowned by all the presiding officers, and documents he hasn't told you where he has found them, and which my classmate Mr. Mahat was able to show you have actually been doctored to fit into the narrative of the fiction. Or, my lord, are you going to believe Githongo when he tells you that the undisclosed man was demonstrating to him a Form 34A for governor, even though we all know the results for governor are not streamed on the public portal? Or, my lord, are we going to believe the four commissioners who we all saw day and night for 6 days and 6 nights? I use the word deliberately, my lady, because we never left our TV screens. 6 days, 6 nights. We saw them announcing results that had been verified, and you were told by Mr. Mahat, indeed, they announced most of them. But when the winner becomes apparent, they suddenly turn around and tell you Mr. Chebukati is a bad man, he should be crucified. Are those the people we are going to believe, my ladies and my lords? Or are we going to believe the petitioner himself when he tells you in his petition and affidavit that the Honorable William Ruto intercepted, altered, staged, and then dumped Form 34A on the e-portal? My lady, why we thought this was the most elementary attempt at the fiction, if you do your math, what the petitioner was telling you is that the Honorable William Ruto was intercepting and changing on average 23 Forms 34A per second in the span of 8 minutes that he claims we staged, dumped, and altered over 11,000 Forms 34A. A question was asked yesterday, my lady. How do you and how, when do you change a Form 34A? And I will invite you to note from the structure of that form that most of the data comes pre-printed. The name of the polling station is pre-printed, the serial number. So the only things you would alter on that form are actually the things written by hand, either by the presiding officer or by the agents or the deputy presiding officer. 3 clusters of people. In the event there are 4 agents, we are talking handwritings of about 7 people. And you're being told the Honorable William Ruto had the capacity to intercept these forms, 11,000 of them in 8 minutes, and alter them. It is in the realm of fiction. And I suggest perhaps politicians should stick to politics and leave fiction to artists. Or are you going to believe, my lady, when you're told that the Honorable William Ruto had this young man with a laptop at the National Tallying Center, and that this is the laptop he was using to do these things called dumping, staging, and whatever not? I think we may have our own views about various citizens, my lady and my lords. But I am struggling to understand who is this fraudster that would walk to a laptop not in some remote place, some inaccessible place where all he has is the network, but he would go to the National Tallying Center with a laptop. And the only reason he has that laptop is to intercept results in the full glare of our TV cameras, in the full glare of all those security men and women that are in that tallying center, under the eagle eye of all the agents. It is simply spurious. My Lord, you are told all these things, and I'm sorry if this is repetitive. The least we would expect is you to be shown a Form 34A that was altered, and not the ones they have cooked as a work of fiction. The least we expected is for them to tell you which are the polling stations in which this interception, staging, and dumping occurred. In short, my duty, my lady and my lords, is to tell you, even if you are to look at this case with your most magnanimous and generous set of eyes, even if you are to be as benevolent as Father Christmas, the verdict you would return is that this case before you is a story full of sound and fury, but which signifies nothing. The case before you is much ado about nothing, and you must tell the petitioner, this is not the Supreme Court of the Republic of Kusadikika. It is the Supreme Court of the Republic of Kenya. It is to be expected that when you move this solemn court, you don't put us in exercises that leave other civilizations wondering why we have to waste the time of the Supreme Court, or God forbid, even the small claims court, dealing with allegations of the type before you, which cannot be believed even by the most gullible person. Let the works of fiction be left to Hale Grissom, James Hadley Chase, James Bond. This is a solemn platform. I regret and I pity all of us that we came to deal with such a spurious matter. Thank you very much. I see the ground now, my lady, to my learned friend, Melissa Ngania. She'll take over on issue number 4 and 5.
Thank you, Honorable the Chief Justice, the judges of the Supreme Court. For purposes of record, my name is Melissa Ngania. I'm going to address the court basically on issue number 4 and 5 as framed by the court. The cornerstone and the grievance of the petitioners in regards to the two issues, number 4 and 5, is the question of the postponement of the gubernatorial elections, as well as the variance of votes within the elective positions. As to the mathematicals, the custodian of the numbers has demonstrated before this court this morning that there is actually no variance, and whatever variance could be explained. But more importantly, Honorable Chief Justice and the judges of the Supreme Court, what is the grievance against our client? That is William Samoei Ruto and Honorable Rigathi Gachagua. I would pick the choice of words as pleaded by the petitioners for obvious reasons. This is an election petition, a presidential election petition that has the crust of proving its standard to the required well laid down principles in law. Now, this is what one Celestine Anyango tells us. She tells us that the grievance against my client is that a pattern throughout the country where the 9 respondents appears to benefit from a fraudulent paddling of votes in violation of the law. They are not sure of that. They've not laid credible, tangent evidence as to the paddling of that votes to the benefit of our clients in this respect to warrant this court to annul the elections as conducted. But what is more disturbing is the position of the Kenyan voter. As laid down by my senior counsel, Fred Ngatia, that is to be found under Article 38 of the Constitution. But more importantly, we have a history as a country. We are a country that has been privileged to legislate on each and every issue that has been litigated before these courts. We are a country that even legislates on the time between which a president should be sworn in office, for obvious reasons, because of the history that has culminated around our electoral law jurisprudence. Now, the appreciation of the cornerstone of Article 38 then would seek refuge in the Constitution of Kenya Review Commission. This court, in the famous BBI case, categorically stated the history behind our constitutional making process. I'll not wish to regurgitate the same, but I'll beg the court, when you retire to write your judgment, to adopt your paragraphs of that decision, paragraph 415 to 441 in that respect. Again, Honorable Chief Justice and members of the Supreme Court, judges of the Supreme Court, then what culminated to the Article 38 of the Constitution. In the final review, for us to get the gist of the Kenyan voter, because all that we are trying to help this court to realize is that what was the will of the Kenyan voter as expressed in Form 34A. And the Kenyan voters said what they wanted, and that is to be found under article page 51 to 52 of that report. Now, coming to my submissions and Article 38 in that respect, their views were finally codified in our Constitution under Article 38 in that respect. For purposes of emphasis and so that we do not lose the trajectory of the Kenyan voter, this is what Article 38 clause 3 says. every adult citizen has the right without unreasonable restrictions. That is the underlying word. The Kenyan voter wants to vote without unreasonable restrictions, to vote by secret ballot in any election.
Bolt helps you move around, but when you move, you generate emissions. To neutralize them, we're planting 11 million seed bolts. They're seeds covered in recycled charcoal to protect them from birds, insects, and rodents. They'll grow into trees like Kirky, Polyacantha, Xanophlea, and other Latin names. And with 11 million seed bolts turning into trees, we'll neutralize all the emissions that your bolt rides generate.
A tribute to overseas Pakistanis on 75th anniversary by UBL.
अपनों से मोहब्बत का एहसास, दूर रह के भी पास, वतन से दूर मुझ जैसे सभी परदेसियों के नाम।
दूर रह के भी तेरी है खुशबुएं फिजाओं में, पेड़ जले धूप में है, लोग बैठे छाँव में, लोग बैठे छाँव में। तू हीरो है वतन का सभी ये जानते हैं, तेरी कुर्बानियों को सभी तो मानते हैं। जिंदाबाद जिंदाबाद सब परदेसी जिंदाबाद, जिंदाबाद जिंदाबाद सब परदेसी जिंदाबाद। तेरे माथे से टपका जो पसीना किसी के हाथ पीले कर गया है। तेरी मेहनत मुशक्कत के समर ने किसी अपने को अपना घर दिया है, किसी अपने को अपना घर दिया है। तू है वो उजाला सब दूर जो अंधेरा करे, रात को हरा के सारे जग में सवेरा करे। किसी को सहारा दिया किसी को के
May it please you, Chief Justice, Deputy Chief Justice. My name is Kithure Kindiki for the first respondent. On 15th August 2022, a mob of people, including people holding senior positions as state officers invaded the dais at the National Tallying Center of the presidential election at the Bomas of Kenya. In what I regard as a very, very orchestrated and clear attempt to interfere with the powers of the IBC to declare the presidential results following the verification and tallying of those results. As a result, chaos erupted. Several IBC commissioners, staff, and other people who were lawfully at the tallying center were seriously injured. To date, nobody has been asked even to write a statement on what happened on that day. Today, no investigations whatsoever have been made by the agencies of state which should be doing this. And to date, this heinous and frontal attack on our democracy remains unresolved, and the perpetrators are marauding around the country, and some of them are in this courtroom. Chief Justice, judges of the Supreme Court, the events on that fateful day mirror what, in our respectful view, took place on January 6, 2021, when a rowdy gang of violent protesters laid siege on Capitol building in Washington, D.C., in the United States of America, following the spectacular defeat of Donald Trump as president of that country in the 2020 election. The chronology of events of that day, the day our country was shamed in the eyes and in the presence of diplomats from all over the world, local and international press. The events are detailed in the affidavit of Mr. Wafula Chebukati, a gallant son of Kenya. That affidavit is before this court and is dated 26th August 2022, particularly paragraphs 58 to 75. This has been corroborated, my lords, my ladies, by the affidavit of Professor Abdi Gulie and Boya Mulu, the affidavit of Boya Mulu, both of which are before this court, and the relevant parts are paragraphs 17 to 37 and paragraphs 9 to 10, respectively. We respectively submit that the aforesaid activities at the National Tallying Center on 15th of August 2022, regrettably perpetuated by emissaries, agents, supporters, and sympathizers of the first petitioner, who is now before this court seeking redress. Those events and those activities amount to nothing short of a flagrant attempt to overthrow the constitution of our country, to subvert the sovereign will of the people of Kenya, contrary to Article 1 of the Constitution. It is our view that those events alone constitute nothing but an attempt to establish a government unconstitutionally, contrary to Article 3(2) of the Constitution. And in our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat. Unfortunately, the jurisdiction of this court under Article 140 does not allow it to punish these egregious acts of treason, but these events must inform the context in which the main petition and its offshoots ought to be adjudged. Curiously, the mentioned public officers, who include civilian state officers, including a cabinet secretary, senior military officials, including the Vice Chief of Defense Forces, Head of Police, Head of Intelligence, the Head of Public Service and Chief of Staff, which is itself is an illegal position under our Constitution. All those people have not denied that they met the IEBC in plenary. The only thing they have told this court is that they went there to try and fast track the declaration of results and not to do what Mr. Chebukati has told this court on oath, which is they went to go and try to have the first petitioner declared as President of the Republic, or otherwise force a runoff between him and my client. With tremendous respect, we ask this court to consider those acts as not only destructive to the independence of our institutions, but more particularly an affront on Article 249, 2A of the Constitution that describes the IEBC and other such independent institutions in the following. It is the submission of the first respondent that there are irregularities, or illegalities that have little or no bearing to the process and the result. This principle, Chief Justice, judges of the Supreme Court, this principle has endured for more than 150 years and was first initiated in the United Kingdom Ballot Act of 1872, Section 13. 2, that the burden of proof in election petitions lies on the person who seeks judicial invalidation of the election. Not on the respondents. This principle has been cited in one of the authorities we have relied in and already highlighted by learned counsel's senior counsel Fred Ngatia, the case of John Mahama versus the Electoral Commission of the Republic of Ghana, 2021. Principle number 3, and this is specific to Kenya and the Maina Kiai decision. The polling station is the true locus for the free exercise of the voters' will, and I'm shocked to see the petitioner and the latest pseudo petitioner, because when I listened to the Attorney General, with due respect, I clearly thought that we are listening to another petition, especially on the issue of Article 138(3)(c), despite the assurances that he was not opposed to any petition, and I think he fell short of saying he's supporting the petitions. What are the specific principles in the interest of time? The first one, those are the 3 are the general principles. What are the specific principles? 1, and what I intend to demonstrate with these specific principles and the general principles is that the answer to the question on the issue number 5 is in the affirmative. That yes, the IBC carried out verification, tallying, declaration of results in compliance with 138(3)(c) and 138 reasons. Number 1, the verification and tallying happened and was done by the chairperson, commissioners of IBC and the staff at the National Tallying Center in the presence of the candidates of the agents of the presidential candidates. And this is in the affidavit of William Ruto, paragraphs in support or in opposition of the petition, paragraphs 18 to 20, and the affidavits of Veronica Nduati, paragraphs 7 to 14. Number 2, the IBC complied because an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners, or a majority of them, is inaccurate and pedantic for this reason, that the Constitution and the Elections Act attributes to the Commission certain acts that are eventually done not by commissioners but by both the permanent and temporary staff of the IBC at the polling station, at the constituency returning the constituency tallying center and county tallying center, and I dare say even at the national tallying center. And that explains why, for example, the Constitution in Article 86(5) and 86(b) and 86(c) talks about the commission, but the work eventually is done by returning officers and in the first instance by the presiding officers. C, B, and C of Article 86 of the Constitution, which is not speaking about the National Assembly election or any other election, but the presidential election. The actions of returning officers, presiding officers, are deemed to have been done by the Commission, and that explains our argument. Number 3, an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners would lead to an absurdity in interpretation, because it is not humanly possible for the 7 men and women who are commissioners, however important they think they are, it is not humanly possible for them to tally results emanating from 46,229 polling stations across the country at the moment. Number 4, verification, tallying, and declaration was done because the right to franchise, Chief Justice, judges of the Supreme Court, this right in Article 38 of the Constitution cannot be subjected to the will, to the veto, or even to the ego of 7 men and 7 women. Even if, as they claim, they think they hold the constitutional veto to try and moderate or alter or balance the will of the people as expressed at the polling station and as received in original 39 A's. Number 5, verification, tallying, and declaration was done. Even, I dare say, Chief Justice, judges of the Supreme Court, even for the 27 constituency results that were not verbalized. They were not announced verbally, but they were declared because they were posted in the website after chaos broke out at the National Tallying Center. I want to invite the court to consider, in interpreting whether what has been pleaded before this court in terms of what the commission did after that risk on life and limb happened. I want to plead and persuade this court to invoke, by way of analogy, 3 doctrines of law. The first one is the doctrine of frustration in the law of contract, where there are contractual obligations to be performed, but the contract is frustrated. Number 2, the doctrine of necessity in international law. And thirdly and finally, the doctrine of supervening impossibility, where there are legal obligations, but the party on whose those obligations accrue cannot perform them as a result of supervening impossibility. Chief Justice, my lords, my ladies, number 6, the IBC verified and tallied and declared all the results because none of the 46,229 from 34 A's have been impeached. Number 7, the IBC verified, tallied, and declared all the results because the tallying that happens at the National Tallying Center is basically clerical. And I think the commissioner should know none of them, including the chairman, has any role whatsoever that is significant other than just recording the clerical and arithmetical issues. And this is so, and this explains why, even when there are discrepancies between what was transmitted through electronic means and what comes as a physical form, the best that the chairperson, as the returning officer, can do is to note the errors in the error form, and only this court can actually interrogate and decide on the fate of those discrepancies. Number 8, verification, tallying, and declaration was done pursuant to 138.3C and 138.10 because an interpretation in the opposite direction would lead to a constitutional crisis where commissioners would think they have a role to veto and moderate the expression of the will of the people of Kenya in the vote, can decide to form factions and have their own candidates, declare their own results, which they have verified in quote and tallied in quotes. Finally, Section 10, 11, and 11A of the Elections Act envisage the commission to include the secretariats and staff, and therefore verification was done according to the affidavit of William Ruto, the affidavit of Veronica Duarte. The tallying was done in the presence of agents at the National Tallying Center. With tremendous respect, I would like to conclude by submitting that this court should find that a petitioner whose agents and supporters are engaged in a kind of behavior that is now of public notoriety, and I invite the court, over and above what is pleaded, to take judicial notice of of the events of that day. A petitioner whose supporters, sympathizers, and agents engaged in those kind of things should not be anywhere near the hallowed ground of a Supreme Court, of the Republic of Kenya, trying to seek relief, among them a relief under Section 80A, that they be declared winners of an election that they didn't win. We submit that the mob that swelled our image, the image of our nation, including the conductors of the orchestra, are now before this court shouting loudest that we must release Barabbas. This court should stop Barabbas and his mob from benefiting from their own malfeasance. We pray that all the petitions, including the submissions by the Attorney General, particularly on this issue of Article 138, those petitions be struck out with costs. I respectfully and humbly submit. And now, with the permission of the Chief Justice and the court, I yield the microphone to Senior Counsel Kirago Kimani to address the court and submit on issue number 7 and number 8. I thank you.
May it please the court, I will not, my name is Kirago Kimani, I will not address you on issue number 7. I believe it's been adequately dealt with by the IEBC and its chairman. I will address you on only issue number 8, and I will try and avoid rehashing what the IEBC and its chairman addressed you, in my humble view, very effectively. This is simply looking at the test that has to be met by the petitioners in order to determine whether the election should be nullified. And you've settled this as far back as 2013 in Raila petition number 1, or it was petition number 5 actually, but it was the first election petition under the new constitutional dispensation, and repeated this in 2017. The long and short of it is that the question you must ask is whether it has been demonstrated that the election was conducted so badly that it was not substantially in accordance with the law relating to elections, in this case the Elections Act and Articles 81 and 86. The burden is squarely on the petitioners to demonstrate indeed this is the case. The word used by Section 83 is magnitude, of such magnitude, really. It is not enough to demonstrate there were irregularities. It is not enough to show that there was a breach of the law. But it has to go beyond that to show that it affected the outcome. Has that been done? I'm not going to take you through the multiple allegations of irregularities and breaches of the law, but I've tried to look at these petitions, the 7 surviving ones, and I think there are approximately 46 allegations of breaches of the law and irregularities. This is a classic case of throwing everything other than the kitchen sink at your opponent. There are a lot of overlaps, but by and large, everything that could be said has been said. And I'll come back to this. The kitchen sink did show up a little later. But I don't want to walk you through all of these allegations. Let's just look at a few of these. It's alleged that there has been an infiltration of the IEBC system. I'm not going to rehash what Mr. Mahat Somane so well explained to you. But I think these petitions are an invitation to this court to lay down the law. It's one of your jobs that it's not enough to show up here and throw things out there and say, we hope some of it will stick. No. People must be held to account. They must be told, show us where the evidence is. And indeed, this is what Rule 9 of the Supreme Court Presidential Election Rules requires, that when a petitioner presents a petition, they will also furnish evidence. Has that been done in my humble submission? No. This evidence of infiltration, in the first instance, was put in various affidavits. John Mark Githongo, you've been told about how he recanted this. There were allegations in various other affidavits. And what happened then? There was a robust response from the referee, the IEBC, and the first respondent. And then what do we have? We have a second burst of alleged evidence in the nature of an affidavit by George Njoroge. And we are not even, we did want to start playing games by saying this evidence should have come at the start, as the rules require. So this case keeps being panel beaten as we move along. And it's not just petition number 5 where this happens. It has happened in another petition where you were addressed about 291 constituencies and not 290. I believe there was a question from a judge directed at this, because there's a short answer to that, but the question was not directed at me. But that wasn't even pleaded. So what we have is a situation where you keep being told new things as we move along. There's another allegation that the IEBC was so dysfunctional that you couldn't possibly have an election that complies with the dictates of Article 86. And we are told that this started even before. Now the question is, why wasn't a challenge made to the mandate or to this institution before the elections? An Article 140 petition is very narrow. It concerns the results and nothing more. This petition has been turned, or these petitions, by many of the petitions, has been converted into an attack on the second, on the chairman or the chairperson of the IEBC. It's not the function of the court to look at the conduct of the chairperson with a view to taking action. You were addressed in great detail as to why or how he has affected the last 2-3 elections. So what were we waiting for when Article 251 tells us what to do? The Leadership and the Integrity Act tells us what to do. Let me very quickly, without going into any more of these 46 alleged irregularities and breaches of the law, just try and illustrate just how bad these petitions are, or how lacking in substance they are. And I will, Mr. Mahat Somane, my land friend Mr. Mahat Somane has spoken to this, but I want to illustrate by showing you just a little bit about what was contained in the affidavit of Arnold Odinga, Ochieng Odinga. And if I could just, if it could be put up, I want us to look at what has been presented before this court. And it's quite easy to come to this court and say, listen, somewhere between the people expressing their will and the declaration of the results, there's been some tampering. Let's look at what they say. Paragraphs 81 to 91 of the affidavit of Arnold Ochieng Odinga says that there was willful, deliberate, and criminal tampering of certain results, and they've identified 41 forms. What I suspect they did not expect to happen is that the IEBC would respond to just about each and every one of these forms. Let's look at just one sample. And before we do that, what are we trying to achieve? We'll look at a Form 34A from the IEBC portal. We will look at a Form 34A delivered by IEBC to the court. We will look at an affidavit from a presiding officer, and we'll look at an affidavit from an Azimio agent, and we'll look at a Form 34A provided by a UDA agent. The affidavit of the IEBC presiding officer is not part of the slides, but we will be able to compare these documents. If we could skip this next slide so that we move quickly. Let's skip that slide, please. Now the question is where the petitioner's fraudulent 34, where allegedly fraudulent 34A came from, and I'll return to that at the end. Let's just look at Kibagare polling station. The next slide, please. If you look at the signatures, one of the signatures is an ODM agent, Mr. Eric Atuma. Now the petitioner in petition number 5 has filed many affidavits in response to the respondents, including the first respondent. They have not responded to this. They have not challenged this, but they put it out there as an illustration of what games were played either by the referee or in concert with the first respondent. So the first thing you note is the signatures of the two agents. The next thing I'd invite you to look at is what the votes were according to the IEBC portal. And Malanfem Mahat Somane invited you. The portal is up and running. Check this. What was the total of votes cast, or what was for the two candidates in Kibagare polling station, stream 2 of 7? Raila Amolo Odinga, 244. Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar Form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says for Raila Amolo Odinga 244 votes. For Mr. William Samoei Ruto 38. What happened to the other votes? Something is fundamentally wrong, and this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Issa Juma of Super Wanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role. That what 138(3)(c) means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Maina Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more, and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. They were on board with every other commissioner. They spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important function, the running of elections. But they say they did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided we will appoint another lawyer on behalf of the IEBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday, we're going to have 200 petitions in 5 years. Why? Because nothing, there are no consequences. We can all come here and be on television, there are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. The only thing that creates wealth is actually working. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kioko Kilukumi will now address you on the 9th issue.
Your Ladyship, the Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, my name is Kioko Kilukumi, and I appear for the first respondent. Our team leader has asked me to deal with the issue raised by Mr. George Oraro, Senior Counsel, in regard to the affidavits filed by Joseph Kinyua and Kennedy Kiara. This court did direct that this first respondent is at liberty to come and place the facts he has before this court, not through affidavits, but we've been given the permission to place the facts because time was running and the court directed we have that time. The first respondent wishes to place it on record that under Article 240 of the Kenya Constitution, there is established a National Security Council. And he is, by virtue of being the substantive deputy president, is entitled to sit in that council. He says in the last 5 years, the council has not sat and discussed anything to do with elections. He further says that matters of election are vested in an independent body, and that independent body is the IEBC. That is the body that has the constitutional mandate to deal with elections. He further says, during that period of 5 years, the Council has not asked the National Security Advisory Committee to deal with IEBC on any matter relating to elections. And he takes the position that the visit by members of the National Security Advisory Committee to IEBC at the Tallying Center was an interference with the functions of IEBC. And it was calculated, given the membership who was sent there, it was designed and calculated to intimidate the chair of the IEBC and to seek to influence the outcome of the election. We ask the court to note that these affidavits were provoked by what Mr. Chebukati said in his affidavit sworn on the 26th of August 2022. From paragraphs 55 to paragraph 75, he has given a subheading and he calls it an attempt to subvert the will of the people. And we invite the court to consider those paragraphs and to see which party is telling you the truth. We wish to refer you specifically to paragraph 66 in that affidavit. And it is an important averment, an important deposition in that affidavit. He says, Mr. Chebukati, when he was at the National Tallying Center, members of the National Security Advisory Committee visited him, and he sat with them after 2 p.m. It is important to contextualize the time. We are talking of the 15th of August. Bomas of Kenya, there is a meeting, and this meeting is attended by all the commissioners. All the 7 commissioners are there. The fact of that meeting is not disputed, or the affidavits filed regarding that matter make critical admissions. The first admission is that indeed Joseph Kinyua telephoned Chebukati and told him, I'm sending my members to you. That's an admission. The second admission is that all the commissioners, and these are the affidavits from Mr. Joseph Kinyua and Mr. Kenneth Kiara, all the commissioners were present. It is past 2 p.m. It doesn't say how long this meeting took. The country had been put on notice. Elections results will be declared at 3 p.m. And once you look at the paragraph I've referred the court to, Mr. Chebukati says the message from this powerful committee was simple: declare these elections in favor of the petitioner, the first petitioner in petition number 5. If you are not able to do so, please massage the electoral data and force a runoff. And now that issue was discussed openly by the members of this powerful committee and all the commissioners in IEBC. The 4 commissioners made it very clear the suggestion from the Security Committee is reasonable and we should actually accommodate it. We should think of doing it. The 3 commissioners, and all of them have sworn affidavit attesting to that. The 3 commissioners said, nothing doing. We will declare these elections in accordance with the Constitution of Kenya, and we will declare the legitimate results. And so we ask the court, you do not have the advantage of witnesses being cross-examined, but you have the ability to look at all the accounts and see which account is more probable. The meeting starts past 2. Elections were to be declared at 3. At 4 p.m., the 4 commissioners are in the Serena Hotel. Our TV screens has been split. One side says 4 commissioners are disowning the results. The other screen is showing us chaos in Bomas, attack on the chair of IEBC, attack on the 2 other commissioners. Do you believe, will this court believe